Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It is Thursday, December 15th. I've taken some of the week off. My Grammy had to be admitted to the hospital with some complications with COVID. And so I've been focusing on taking care of her and keeping my mom away from there to keep her from getting COVID. But I had a little time today. She's doing better. Going to go to a little rehab facility to get some strength back just for about 2 or 3 days. So very, very grateful. It was not any worse than it was. Thank you, everybody, for your well wishes. She has read them and is just touched that you guys love her. So she's easy to love. All right. So what are we going to do today? There's been some filings leading up to the sentencing in George's trial. Well, trial's over. We're going into sentencing now. So we're going to go through those. I'm condensing some of it, a lot of case law cited, and we could spend all day doing that. But first, music fact of the day. What is the meaning of the song Purple Rain, right? It's a classic, such a great song. And so according to Prince, when there's blood in the sky, red and blue equals purple. Purple rain pertains to the end of the world and being with the one you love and letting your faith or God guide you through the purple rain. That's what he said for the song's meaning. Love it. Have to listen to it when I'm cleaning up later. All right. Reminder, Monday, 10 a.m. is George's sentencing. It will be live streamed. I'll do an episode later that night. We do anticipate family will make impact statements that should be very powerful. So we're going to bring that to you Monday evening. And so let's hop into these filings. One thing Big E put out yesterday that we have not put out there yet is a letter that Angela Wagner wrote to Fredricka, which is Billy's mom, after she pled guilty. And she wanted to sort of clear up with her what she meant when she pled guilty and what it means. It says, Granny Wagner, how are you feeling? Any better? I'm sure you're not. I'm sorry for all you're going through. I wish I could be there to talk to you in person and explain. There's so much no one will ever know. I'm sure Billy will explain to you when the time comes available. Just know that all that was said in court that day I changed my plea was not the truth. I was given 2 options by my attorney. 1, take the plea deal, plead guilty to conspiracy, and at least get a chance to go home someday. Or 2, take it to trial, which Jake would have to testify against me. And I could never do that to him. He is hurting so bad as it is. And since the trial will be held in Pike County, it would not be fair because the Rodens just want someone to blame. And they're related to half of Pike County. So I would end up with life in prison. I have to be able to see Jake and George and Billy and hug them at least one more time before I die. This plea will give me that chance. And I have to be able to have some kind of relationship with Bolvon and Sophia. All that ever mattered to me was being a mother to George and Jake and then a grandmother to Bolvon and Sophia. That was my purpose in this life. I'm so lost. Sometimes I have no one to take care of. I've lost my family. Billy, I miss him terribly. I worry about him, about his health. But then I will see them on TV or someone has worked with them or has a boyfriend in jail where they are or actually give me some news. From what I've heard, they're all well-liked and respected by inmates and officers. But that is who we really are. She is so delusional, y'all. We are nothing like the media portrays us to be. If people only took the time to really know someone before judging. Each day I commit myself to God and try to be the best Christian I can be. I try to let his light shine through me each day. Yes, I've repented all of my sins. I have an internal life with Jesus waiting on me. I study God's word each day, trying to draw closer to him. I also watch Dr. Jeremiah and Joel Osteen every Sunday morning, 9 a.m. and 8:30 on channel 39 Lifetime. I trust God with everything. I know he will take care of all of us, no matter where we go or what happens. I have heard from some of the ladies in here that have been to prison that it's a very big church program. And if I want, I can volunteer to help out, which I do intend to do. I hope George, Jake, and Billy realize it is not what others think or say about us, only what God thinks. Please tell Robin I'm so sorry and that I've always thought of her as my sister, not my sister-in-law. I know she's very protective of Billy, but please try not to be too mad at me. I love her and I really want to come see her when I get out. I know that will be a while, but I'm trying not to dwell on the amount of time. It's 30 years, by the way, if you need a reminder there, Angela. Hopefully it will go faster that way. Thank you for everything. This is not enough gratitude for all you do or have done, but I'm very thankful. Just to let you know, too, they did give me back my privileges, all of them. So if you want to send cards, pictures, or write, you can. If you have any good pictures of all of us, you can send them. Usually 5 per envelope. If not, it's okay. Before I go, I was wondering if you could send me a couple of pair of pink or gold reading glasses, 250 strength or any brand. I usually get them from the doctor, but they are out. Just notified me this morning. I should have some sent via Amazon because they do not know when they are getting more in. The ones I have, one of the earpieces is broken. I've had them over a year now. Thank you, and thank you so much for the shoes. They have helped my feet greatly. Love, Angela. P.S. Have you seen or heard anything about Bulvine or Sophia? Maybe not so much about Sophia, but I thought you would Bulvine, seeing Sandy and Vivian close by. I heard that they are really growing and doing good in school. I would love to have updated pictures. Kids change so quickly. So that was the letter that she sent Fredricka after she pled guilty to get her plea deal. And so I wanted to read that. Very delusional. I want to see everybody one more time before I die. Well, right now, Jake's going to prison for the rest of his life. George probably headed that way Monday. And Billy, who I think will take it to trial, probably going to be the same fate. And if she thinks that these grandkids are going to remember her when she's 84 years old and they have lived 98% of their life without her at that point, she's crazy. Not to mention that when these kids grow and get older and can read the internet and talk to family members and friends, when they learn exactly what happened and how it happened and who it was planned by, if those kids want to see Angela, I'll eat my shoe. But, I guess maybe she has to have some hope in there. But, if you didn't want to be in there, you could have just been civil about custody and visitation, and then everybody would be happy. But here we are. So zero sympathy, y'all. All right. So the filings that we have now, the first one we're going to get into is where his attorney has filed for a new trial based on the fact that death was taken off the table, but the jury was picked death eligible. So Jake Wagner waived his attorney-client privilege during the course of his direct examination. Jake voluntarily testified about his otherwise privileged communications with his counsel about the facts of this case. Defense counsel here issued a subpoena for his lawyer's notes and documentation of this conversation. The court held a hearing and quashed the subpoena. Counsel requested the notes be placed under seal for appellate review. The court denied that motion. Counsel renews that request and brings to the court's attention a new case on the attorney-client privilege issued May 5th, 2022. They cite some case law. Mr. Wagner asserts that Jake voluntarily testified concerning his privileged communication and thus waived the privilege. Further, Mr. Wagner's right to cross-examine Jake under the 6th and 14th Amendment of the U.S. Constitution have been violated from the Ohio Constitution. Jake was the state's key witness, and his credibility was paramount to the state proving his case against George Wagner. The inability of George to cross-examine Jake on the story he told to his attorneys has denied George a fair trial. Inconsistencies are often key for a jury to determine one's credibility. Jake admitted he lied to his attorneys, but George has been denied the opportunity to determine the exact lies and what his counsel's notes can prove about his lies. The death qualification process makes the jury prone to conviction, and the defendant was denied due process when the state had no serious intention to seek death, but only to prevent the defendant from having a bond set and or use the death penalty as leverage against him. They list a lot of case law backing this up. We're not going to dig into it. In this case, the state cut a deal with Jake Wagner, so the death penalty against George Jake, Billy, and Angela would be dismissed if Jake agreed to testify against George to the state's satisfaction. However, George has had to go through the process of selecting a death-qualified jury because the state refused to dismiss the death specifications before trial. That is a tongue twister. Try saying that 5 times. The state fully intended to dismiss the death specifications against George, but its refusal to do so before jury selection has denied George due process, a fair cross-section of the community to serve on his jury, and has otherwise made the jury more conviction-prone. During the guilt phase, as evidenced by the months-long jury selection process and trial, then a relatively, I think it got cut off here, short deliberation by the jury after only 1 day's deliberation, in spite of the more than 1,000 exhibits and testimony of more than 50 witnesses. In fact, the death specifications were only dismissed the moments before closing arguments and after jury instructions had been haggled over for days by the parties. The U.S. Supreme Court has acknowledged that death-qualified jurors are more prone to conviction. The distinction in this case is that the state never seriously sought the death penalty against George and had every intention of dismissing death as it did so eventually. The state pursued a theory that George was complicit in the aggravated murders, but he was not the triggerman, as Jake admitted to being for at least 6 of the victims. George actually neither shot nor killed anybody, and thus the case for a death penalty against him was much weaker than Jake. Jake received a sentence of life without parole. Nonetheless, George was forced to have a jury that was conviction-prone and denied a fair trial and due process by the improper use of the death penalty against George and or to use the threat of a death sentence in the hope of persuading George to enter into plea negotiations, as Jake did along with his mother, Angela. Such gamemanship by the state was improper and misconduct. The prosecutor is the representative, not of an ordinary party to a controversy, but to whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that of guilt shall escape or innocence suffer. He may prosecute with vigor, indeed, he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. I think he's talking about the state here. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. The court must grant a new trial for the above stated reasons and or preserve the material for appellate review with respect to the subpoena issued to Jake's testimony. The court must order further relief as justice requires, including a new trial with a non-capital jury. So we'll see what happens. Don't think that'll go very far, although I do think they'll file an appeal for sure. All right, so the defendant's sentencing filing, this was filed on behalf of George, where they're respectfully requesting a sentence that allows him a meaningful chance at parole. He's been incarcerated more than 4 years, 24 at the time of the offenses. Jake, the actual killer of at least 5 of the 8 victims, received life without parole. George was convicted under a complicity theory and did not kill anybody. Angela, the mother of Jake and George, and perhaps the mastermind, received a penalty of only 30 years and will be released in about 26 years. She was not held legally accountable for any of the homicides. Any sentence or combination of sentences, whether through consecutive sentences on various counts and or specifications, including firearm specifications that denied George a meaningful parole eligibility date, is cruel and unusual, contrary to the dignity of humankind and contrary to Article 1's Section 9, 10, and 16 of the Ohio Constitution and the 8th and 14th Amendments of the U.S. Constitution. The recent decision of the Supreme Court of Canada is enlightening and applicable. Canada outlawed a sentence of life without parole in any case. A man shot and killed 6 people at a mosque and injured 5 others based on legal principles that are nearly identical to the U.S. and Ohio constitutions. The Supreme Court of Canada held that life without parole was unlawful and beneath the dignity of humans and cruel and unusual. A sentence of imprisonment for life without a realistic possibility of parole is intrinsically incompatible with human dignity. Such a sentence is degrading as it negates in advance and irreversibly the penological objective of rehabilitation. This objective is intimately linked with human dignity in that it conveys the conviction that every individual is capable of repenting and re-entering society. This conclusion that a sentence of imprisonment for life without a realistic possibility of parole is incompatible with human dignity is not only reinforced by the effects that such a sentence may have on all offenders on whom it is imposed, but also finds support in international and comparative law. A sentence of imprisonment for life without realistic possibility of parole is different in nature from a sentence of incarceration, for which a review mechanism exists, in that the former deprives the offender of any prospect of reforming and re-entering society. A variety of expressions, all of which allude to the fact that the offender will inevitably die behind bars, have been used to describe the nature of a sentence of life in prison, such as living death sentence, death by incarceration, virtual death sentence, prolonged death penalty, delayed death penalty, death sentence without an execution date, and the other death penalty. A felony sentence must be reviewed on a case-by-case basis. Consecutive sentences here are not warranted, since the imposition of such consecutive sentences would likely result in no possibility of parole, and thus violate the articles in the Ohio Constitution and the federal Constitution. The imposition of fines and court costs should be waived, since the defendant is indigent, and given the length of the expected sentence, Mr. Wagner will have no practical means to ever pay the fines and or costs. It should be noted that the state in Jake's proffer indicated it would not likely oppose fines and costs in his case. George Wagner IV should receive a sentence with realistic parole board dates, at which time the board can properly determine whether he should be released from prison based on his conduct and contemporary standards. Human dignity demands as much. The court heard his testimony and background during the trial. He was not the actual killer of any person, nor did the state argue he was such a killer. So that's the defense's argument. I think it's interesting about the fines, and I don't know if this has something to do with it, but when you have restitution that you have to repay when you've been convicted, it affects like getting your commissary stuff. It affects any money people put on your books, because a large percentage of that is docked. So let's say I send George Wagner $100 once he's been sentenced and they impose fines. He may get 90, the court or would get $90 of that, and he may get $10. I think maybe that's why they're trying to claim that he's indigent, so that it's not, something that he has to deal with for that reason. I can't think of another. It is true, though, if they find him $1 million, he's never going to pay that back. I think you get 15 cents to maybe make license plates or whatever they do there. So the state's sentencing guidelines of what they're asking. They're asking he's sentenced to max and consecutive sentences for each count. He was found guilty. He committed the worst form of these offenses, shows no remorse, and the victims did nothing to provoke the offenses. So they say he was indicted November 2018 on 22 counts, including 8 aggravated murder with death specifications. They acknowledged the plea agreement from Jake and his testimony to the satisfaction of the state that ultimately removed death. The state could not agree with statements counsel for the defense made periodically throughout this case. Anyone who participates in the slaughter of 8 completely innocent victims deserves the death penalty. George and his family deserve death for the aggravated murders. The victims did nothing to provoke the offenses. Some were killed because they simply were there the night of the homicides. If other people had been there, they would have been victims. They were killed indiscriminately. The victims were in what should have been the sanctity of their own homes. 6 victims who were in their beds, and all were unarmed and had no knowledge of the horrors that were going to be visited on them that night. Most assuredly deserve the death penalty. George did nothing to warrant the dismissal of the death penalty. We don't know what they, meaning the jury, would have done should death been kept on the table. There would have been an opportunity for the defendant to present mitigation. The jury could have ultimately recommended a death verdict in this case if Jake had not done what he did by entering into and fulfilling an agreement with the state, and by doing so, sparing his brother's fate. It's important the court consider when determining appropriate sentences the fact he may have only been complicit in some of these crimes should not detract the possibility the jury could have given death. Aggravated murder was premeditated. It is doubtful that any of us have seen a case involving the amount of premeditation that exists in this case. At least 4 months of it, and up to and including as they were traveling along the road up to the first home that night when the defendant's father asked if the defendant and his brother were sure about what they were about to do. Even then, they continued on their way with their original long plotted out plan. If death had remained and the jury unable to come to a unanimous decision about death, it's hard to imagine they would have recommended anything less than life without parole to each aggravated murder count. Sentencing is to protect the public from future crimes by the offender and to others, to punish the offender and promote effective rehabilitation while using minimum sanctions the court determines accomplishes those purposes without imposing an unnecessary burden on the state or local government resources. Additionally, it would have been demeaning to the seriousness of the offenses and to the irreparable impact the defendant's crimes had not just on the 8 victims in this case who lost their lives for no legitimate reason, but also demeaning to the impact on the families of the victims in this case. Their 4 toddler and infant children were orphaned that night, and there is clear and extensive impact on the surviving other family members in this case, some of whom this court heard from during the trial, and some more of whom the court will likely hear from at the sentencing hearing in this case. Anything less than the maximum and consecutive sentences in this case would disregard and demean all of the above. Jake received maximum for the same offenses. To sentence George to maximum would be consistent with sentences for similar crimes by similar offenders. They asked the court to consider the victims' injuries as well as their ages. 4 were 20 or younger, the youngest being 16, which was little Chris. The oldest victim was 44. They were asleep and robbed of the ability to defend themselves. They were incapacitated and unaware of the crimes being perpetrated upon them. They weren't even able to summons for help. Obviously, the victims suffered serious physical harm, and the offender's relationship with the victims and their families facilitated the offenses, and he also acted part of an organized criminal activity as determined by the jury. Lastly, at least to one of the victims, the defendant's co-defendant was a family or household member, and the defendant himself was once a household member with the same victim, and the offenses were committed in the vicinity of 1 or more children other than the victim. In this case, some of the children were actually in bed with the victims at the time the defendant and his family murdered them. All of these factors support a finding that the defendant's conduct was more serious than others who commit similar offenses. The victims did nothing to facilitate these offenses as their death sentence was carried out pursuant to the Wagners' unending insistence of having full control of their toddler children. George knew very well the mission of the night and was supposed to kill Chris Sr., but did nothing to warn the victims, stop the crimes, but he aided and abetting in committing some of the most terrible crimes ever committed in the state of Ohio before, during, and after that treacherous night. They say he's likely to reoffend and refer to his criminal activity dating as far back to when he was 9 or 10 that he testified to, such as the thefts, arsons, And due to the fact that George was never caught and prosecuted shows how coordinated this criminal empire was. He takes no accountability. He clung to his strategy of not to cave and not to crumble. They asked for consecutive sentences for the firearm specifications. That should total 81 years. What are they asking for? 8 life without parole sentences, 81 mandatory consecutive years, and that's 147 years and 174 months. So the 81 years they're asking mandatory and to be served first. So do I think he'll get life without parole? I do. I don't think it will differ from Jake's at all. Conspiracy, you don't have to pull the trigger, remember? And he was found guilty for the aggravated murder, so I think it will be life without parole. And probably will go pretty quiet for a while, and then we'll hear of this being sent for appeal at some point, I'm sure. So the goal maybe is later tonight or tomorrow to get caught up on the Idaho homicides with the University of Idaho murders. A few developments, as you know, the white car, that kind of thing. But I'm going to keep Wagner stuff separate, and we'll keep the Idaho stuff separate. So I hope you guys have a great day. Feels good sitting back here. Missed you guys. But next week, full force. Got a full week ahead. So may see you tonight or tomorrow. But in the meantime, hope you have a good rest of your day, and we will see you soon.